So what if we change the scenario slightly and the driver of the work vehicle is texting and hits the drunk driver who's stopped at the red light?
Okay, so that still qualifies as workers' compensation because they were in furtherance of the employer's business. So because the driver was texting doesn't mean that they don't have a workers' comp claim. So the passenger can file a workers' compensation claim, and actually the driver who was at fault for the accident because he was texting can also file a workers' comp claim because in Pennsylvania, negligence is not part of workers' compensation, so we don't have to prove negligence on his part.
And in this scenario, you'll notice I didn't raise my sign. The reason I didn't raise my sign is because there's no one left to sue. So your only avenue of recovery here would be, like Craig said, that comp claim. And the reason is because even though in this scenario we still have a drunk driver, they didn't do anything to contribute to the accident. Based on the fact pattern, they're just sitting at a steady red light. So there's nothing indicating there's any negligence on their part. The only person that did act negligent would obviously be that coworker who was texting. Frustrating thing about Pennsylvania law is workers' comp provides a lot of nice benefits. However, the trade-off there is you can't sue your employer. And additionally, you can't sue your coworker. And in this scenario, the coworker is the only person left to sue. And since under Pennsylvania law, you can't sue the coworker, there is no additional personal injury claim there.